Well, welcome everyone to another live episode of Level Up Law. We're here at South Carolina Legal Services every Tuesday at noon. We're leveling up your legal knowledge about an area of law that we practice in. I'm Senior Staff Attorney Susan Ingalls, and I'm here with our producer in the background, Pat Muller, today, Director of our IT department. And you are viewing live our attorney, Stephanie Vanderhorst, who is in our Charleston office and is our employment law unit head. And Stephanie and her team have put together a great series for us this month with Second Chances Month to talk about all the different barriers to employment that some of you are facing. And today, Stephanie will be explaining how to modify your child support obligation in South Carolina. So welcome, Stephanie.
Thanks, Susie.
Then before we get started, we do want everyone in our audience to know that this is not legal advice, just general information for you. So if you do need the help of a lawyer on this or any other area of law that we practice in here at Legal Services, you can call our intake line or apply online, which is 24/7. All of that information will be provided at the end of Stephanie's presentation today. And also, as a reminder, all of our episodes are posted on our YouTube channel to the Level Up Law playlist, usually within 24 to 48 hours. Now, Stephanie has graciously agreed, if time allows, to answer general questions at the end of her presentation today. So if you do have any questions, you can put them in the question box that you see on your screen. And I think we'll be looking at those at the end of Stephanie's presentation. So definitely put them in there and we'll see if she can answer. So at this point, we're going to go ahead and open it up for this great presentation by Stephanie Vanderhorst. Take it away.
Thank you. Oh, okay. So as Susie mentioned, April is Second Chances Month, and basically that month is dedicated to assisting individuals re-entering the workforce from incarceration to getting back in the workforce. So the employment unit here at Legal Services, we put together a series of episodes with Susie's help and her allowing us to use her platform here at Level Up Law to just do some tutorials regarding those things. Last week, my colleague Tiffany Love presented on driver's licenses, and then this week we are presenting on child support modification. And then, of course, we'll have another episode next week. So just to dive right in, there are lots of barriers to re-entering the workforce after incarceration. And one of those barriers can be child support, because if you had a child support obligation that was in effect at the time that you might have been incarcerated, you're going to face some trials and tribulations when you get out, because that has continued to accrue usually during your incarceration. That can lead to contempt actions in family court, and the result of that can be anything from a driver's license revocation to additional incarceration for contempt of court. So we are going to go through the steps of modifying that child support obligation so that it becomes hopefully affordable going forward, and you can get back in compliance with that order so that you're not back in the system of reincarceration for that contempt of court. And of course, that can lead to losing jobs and homes and things like that. So I'm just going to go through some legal terminology here regarding child support modification, because it is a court action. And I'll be using terms that are legal terms that everyone should be familiar with so that we can all be on the same page. So plaintiff is a person who files an action in court, the person who initiates the action. If you're trying to decrease the child support, you're the plaintiff if you file the action. the defendant is the one who's basically being sued, for a better term. The person that you think is causing you harm, or that you need to name in order to get the relief that you're seeking. A payee, that's the person who receives child support. Now, gross monthly income that's your income number that child support is based on. And gross means that's before any deductions you have for taxes, insurance, expenses. Gross monthly income. And this can be an issue for some people because since child support is based on that gross monthly income, it doesn't take into consideration all of the expenses that you may have. Okay, so generally, in order to modify an existing child support order, there must be a substantial material change in circumstances. So something has to have happened since the child support obligation was put in place by the court that has made the parties unable to comply with that child support, basically. So if you're the individual paying child support, something must have happened to your income or to you so that you're not able to make that child support obligation anymore. Now, the court can consider several factors. The most important factor would be the parent's income. So what wages the person paying child support is receiving and what the person receiving child support is receiving, because child support is based on both parents' wages, and then the amount of support is based on the comparison of those incomes, basically, or simply. Okay, what else? In addition to wages, if one individual has had another child or has been held responsible for another child in their home, then that can also change the child support obligation, because the number of children in the home is relevant to that child support obligation. Now, this can go both ways. If the payee, the person receiving the child support, has had another child, then that could also be the basis for increasing a child support order. Now, if either parent were injured and is unable to work because of that, that is always considered a substantial material change in circumstances that would warrant a change in that child support order. So you have to have been evaluated by a medical professional, and a medical professional has said you are no longer able to work. And generally what you really need is an adjudication by Social Security that you're disabled in that instance. Other things that the court considers but are not as important are your cost of living, your health conditions. If you're not disabled, that could mean you were working in a physical job as a physical laborer, but you sustained an injury that has made you unable to continue work in that field. You're still able to work, just not in your previous field, and because of that, your wages have decreased. That could be a factor. The custody arrangement, if the custody of the children have changed, or if one has turned 18 and left high school, then that could be grounds for a reduction in child support as well. Any other child support orders that have been put in place that maybe weren't considered in this particular order, and then any assets you may have. Okay, so DSS has a great child support calculator available on the web. You can actually just Google South Carolina DSS child support calculator, and it'll give you an estimate of what your child support obligation could be based on the information that you have about yourself and about the other party involved. So it requires both individuals' income and, of course, the number of children in the home, what the custody situation it looks like. Are you sharing custody? Is it week on, week off? Are you Are you only getting weekend visitation? You know, if you're sharing custody and you have the child every other week, then your child support obligation is going to be less than if you're only seeing the child every other weekend. Also, I will say that this is not a guarantee as to what your child support obligation will be. However, it's a good place to start, and it'll give you an idea if even if you're even eligible, or if you should risk trying to modify it. Because in some instances, it could go up and not go down, which is not usually what people are looking for. Okay, so things that you need to consider before filing a child support modification. Do you have any existing warrants for contempt of court? Why aren't you able to pay your child support? If nothing has changed, if you know you're still able to work in the field that you were working in when the child support was ordered, if it's the same number of children, if the opposing party's information is the same, then you're likely not going to see a reduction, and it wouldn't be worth the time or money in filing the child support modification. And in some instances, if the opposing party's situation has deteriorated, but yours has not, that could end up increasing your child support obligation as opposed to decreasing it. Okay, and the last thing you need to consider is whether or not your child support is basically private or it's through DSS and child support enforcement. If you're paying the other parent directly, that's a private action. DSS is not involved, and that requires a different method than if DSS is enforcing that child support order. And if DSS is enforcing that child support order, then modification can be somewhat easier than if they aren't. So child support modification through DSS is simpler because you don't have to file your own action in court. So they can either, DSS can do several things, two of which are establish and modify child support orders through the family court. And they can do that by request of either party. So if you are currently paying child support and DSS is enforcing that child support order, you can request a review of your child support obligation simply by sending DSS a letter. I will also say if you're in a private child support case and you would like DSS to enforce the order or to review it for a possible modification, you can assign your child support to DSS as well, even if you're not the person receiving the child support, if you're the person paying it. Now, I will say, once you do that, you would be responsible for any court costs associated with that. And so if you're paying child support through the court, there's an additional 5% fee added to that monthly obligation. So keep that in mind. So basically what you do is you write a letter saying, my name is such and such. I am currently paying child support through this case. You should have a case number for your child support order. I'm requesting a review of my child support order because things have changed. Those things are. You send that letter to Child Support Division, Special Collections Unit. I have the address here on the screen. It's in Columbia, South Carolina. And DSS will get it, and they will set up what's called a negotiation conference between you and the other party. You guys will come together. You'll each bring your evidence of your current income and obligations, anything that has occurred that has changed, proof that a child has graduated high school and left the home, or that you shouldn't be paying child support for them anymore, proof that your income has changed, recent pay stubs, tax returns, you don't have, a recent pay stub, medical documentation if you have suffered some sort of health condition that makes you unable to work in that previous field, or if you're disabled, proof that you're disabled from a doctor, from Social Security. The Child Support Division will attempt to come to an agreement between all parties. So they'll collect your items, they'll collect the opposing party's items, they'll review them, they'll do a new calculation, and then basically they'll say this is what it is, it should be reduced. The opposing party can agree or not agree. If they agree, you're good, your child support is reduced. If they don't show up, you're the only person submitting evidence, and if your evidence supports your position, usually what you end up with is a child support reduction. However, if the opposing party doesn't agree, then you're going to still have to go before the family court judge and explain what grounds you have for a modification, and of course submit those documents to the court. Now, if you are denied a modification, if DSS says you're not entitled to a modification, you can still request or file an action in court to have the court evaluate the case to see if there's been a substantial change in circumstance with modification. Modifying child support obligations in court. Now in South Carolina, we've developed self-help forms that are available on our court's website to help individuals looking to modify their child support on their own. All right, this is our SC Court's website. You guys are the general public, so it goes right to that first site, first window, tab, I'm sorry. And you can just look through all the information. It has expungement information, the family court public portal, code of laws, the lawyer directory for the bar. And then right above that, you see SRL child support packets. So SRL stands for self-represented litigant. And you can click on that and it will take you to the page that contains all of the documents and forms needed to file a modification action. If you're the plaintiff, which is this top one, child support decrease plaintiff, and then you'll see self-represented litigant, child support decrease, defendant. And then if you're looking for an increase, which we aren't discussing today, those forms are available as well. So the most important document, I think, in this packet or on this sheet is these instructions right here. So it's a 15-page instruction booklet, and it goes through everything that you need to know about filing that modification on your own. It also has, I'm sorry, I'm getting over a little cough. It also has instructions for filing or completing your paperwork and every document that needs to be completed. It goes through filing, service, requesting a hearing, and then even a little checklist at the end, and an example of an examination from the judge. So when you get in front of the judge, what points you need to hit in order to make sure your case is made. So I always say sometimes we do these kind of clinics in person, and I always, when I'm there doing it in person, I always tell people that this is the most important thing. If you ever get lost, you just need to refer back to this instruction sheet. So in addition to that, you have all the other documents that you'll need. Now, I'm going to click back over to my slide. Okay, so every action begins with filing of court documents. And the first filing, there's a lot. So there's a cover sheet, certificate of exemption, information, summons, complaint, verification, IFP, which is called the Informa Pauperis, and a financial declaration. Now, I'm going to pull up one of those right now, and we'll start with this family court cover sheet. And as you can see, it's a form with a lot of boxes. And then this header at the top. And this header is in all court documents. Anything the lawyer files, it's going to have this header. And it basically tells the court all of the relevant important information. Where we are, we're in South Carolina, what court we're in, can say family court, maybe depending on what you're doing, it could say magistrate court. And then you are going to fill this out on every sheet that you file with the court. And this is always going to be the same information. Now, you're going to put the county in which you're filing. It may not be the county in which you live, but it'll be the county that your child support order was issued from, that family court. The judicial circuit, every county's court is assigned a number, and that's what goes here. I'm in Charleston. Our circuit, we're in the 9th Circuit. We're also, I also practice in Berkeley and Dorchester and several other surrounding counties. Berkeley is also the 9th Circuit, but Dorchester is the 1st Circuit. So those are also listed on the SC Courts website. You can pull them up. If you have court paperwork, your last child support order, that's going to tell you what circuit you are in as well. Okay, and then we move down to plaintiff, that's you, and then the defendant who you're paying child support to. Now this docket number, the court's going to assign the docket number, and that's not something that you're going to fill in your first filing, but you will fill in after that in any subsequent filings that you have. All right, now this is possibly the most important piece because it is going to tell the court how to reach you. And if the court can't reach you and you don't move forward with your case will be dismissed. So you need to put your name, who's submitting it, if you're not represented by an attorney, your address, your email address, your telephone number, and any other ways the court can reach you. Now, in a child support action, you're going to click one of these subject matters over here under the heading support. So modification of child support private is usually what you're going to check when it's when DSS is not involved. And of course, if DSS is involved, then you would check modification of child support DSS. Okay. You'll sign it and you'll date it. And then that's just the cover sheet. And I'm just going to go through the others really quick. Otherwise, we could be here for hours. But your initial filings are going to consist of that cover sheet, a summons. Now, the summons tells the defendant, the person that's receiving the support, that they're being sued, basically, and that they have a certain amount of time to answer, which is 30 days, and that they need to file an answer and how to file that answer. Okay, so you'll have to fill out this heading again, just like you did before, date, and of course your contact information. All right. Now, the nuts and bolts of the child support modification is, of course, the complaint. Now, the complaint sets out everything that you need to tell the court in order to get the relief you're requesting, which in this case is your child support decrease. Here you have that heading again, just as I promised. And then it has all of the relevant information regarding your case. Now, this complaint, super simple, it's one page and it's fill in the blank. You, the defendant, who you're paying to, the children involved, what the current order says. So if you're paying $100 per week, you put $100 per week. If you're paying $450 per month, you put $450 per month. And then you also need to, I'm sorry. Let the court know what those substantial change in circumstances are. I've lost my job, I've become disabled, a child has left the house. And then check the boxes that apply. There's several here. Insurance, decreasing child support, and then unreimbursed medical expenses, which are all kind of considered as one in support. And they're that's considered in your child support obligation. sign, date, contact information, always important. And let's see, lost my cursor. Okay. All right. Sorry. Okay. Now, there's other documents that are also required. One, of course, is a verification. It simply says that you, everything you've stated in these documents is true to the best of your knowledge, and that it needs to be signed and notarized. Basically, you're swearing to the court that you're telling the truth. And if you're not telling the truth, you can be convicted of perjury. So everything you put in those documents needs to be true to the best of your knowledge. Now, well, I would say, at least for as far as South Carolina Legal Services is concerned, one of the most important documents that you need to file would be an informa pauperis. Now, informa pauperis is a Latin term, and basically it means that you can't pay filing fees and costs associated with the litigation, your decrease in child support request, and you need the court to waive those fees. So, in addition to the summons and the complaint and the cover sheet, you're also going to need to file this document. And it says, I can't pay the filing fees. I swear I can't pay them. Please waive them for me so that I can proceed in court. Now, you'll sign this in front of a notary, and then it'll go to a judge. The judge will look at this, at your documents, and they'll look at what's called a financial declaration. And based on your income and expenses, the court will either approve or deny that request to proceed in informa pauperis, to proceed without paying those court fees. Now, if you're approved, you can go forward. If you're denied, you'll have to pay the $150 filing fee that's required to file any new action in the family court. Okay. So this financial declaration is the most important document when filing for a modification of child support, because it's going to have all of your financial information in there that the judge is going to look at and consider when making that final decision. And it's very important that everything on here is correct to the best of your knowledge. So as you can see up here, that's just general information regarding each party. So you would either fill it out as to husband, father, or wife, or mother, depending on what the original child support obligation identified you as. And put in your earnings. The top part is for income. So it covers all types of income, earnings from employment, tips, commissions, if you work, say, in food service or you're a salesperson, pensions, retirement, if you're not currently working but you're retired, any other employment income, any side hustle you may have, a place for VA benefits, disability, workers' comp, unemployment, it covers it all. If you're receiving any child support or spousal support from another relationship, that also goes in there. And then if something is not specifically covered, you can also, there's a line for that as well. Now, this is monthly income. So in some cases, you might have to do a little math depending on how you're paid. If you're paid monthly, that's the easiest. Of course, that's not usually how people are paid. Usually people are paid bi-weekly. If you're paid bi-weekly, there's a couple of ways to figure out, what your monthly income is. My general rule of thumb is that I take the last couple of pay stubs, add them together. Average them, stay with me, multiply them by 26 and divide by 12. So if you're paid bi-weekly, you get paid more than twice a month, because there's 52 weeks in a year, and that's just how that works out. So it can be mathematically complicated. So the rule of thumb is an average multiplied by 26 divided by 12. Or you can also, there's other ways to do it. Basically, if you average out the length of all months together, there's 4.33 weeks in every month. You can do it that way. But keep in mind that this is monthly income. Now, that goes for your payroll deductions as well, because those are, if you're paid bi-weekly, those are also going, you can't just multiply it by 2. You're going to need to multiply that by 26 and divide by 12 for all of these, since it's done on a bi-weekly basis instead of a monthly basis. Now, if you're paid semi-monthly, twice a month, that's easy. You just add up those two paychecks. All right, so I'm just going to scroll down. And on the second page, you'll see your fields for expenses. You need to put in all of your expenses: rent, note or mortgage, food, utilities, telephone, all of that, auto payment, insurance, taxes, gas, and maintenance. All of that goes in. Work-related daycare, you may pay. Child support from another relationship. So if you're paying child support for another child that is not the subject of this particular action, that's very important, and that's going to be taken into consideration in this child support case as well. And then additional expenses below. You'll total these, any other installment loans, debts, obligations. And if you scroll down, you sign, you swear before a notary, so you have to have it notarized as well before you submit it to the court. All right, so this financial declaration gives the court a picture of what your finances look like. So it's very important that the income that you're putting in this document is true to the best of your knowledge, so that you can get an accurate evaluation from the court. I'm gonna flip back to my PowerPoint. Okay. All right, so I just went through the financial declaration. This basically tells you just what we went over, all of the fields, what you need to put in, and then it must be notarized. Now, the second part is filing. All of this information is in that instructions packet, but the rule of thumb is that you make 2 copies of all of your originals. You take them to the court, file all of them. The court will keep the originals, and it will give you 2 stamped copies back. One is for your records, one is for the imposing party. Okay, now, service. This is what usually trips people up. Once you've filed everything, you have to serve the opposing party. Now, you can do that in several ways. The best way is to take it to the sheriff's office in the county where that individual lives. They have a civil processing department, and for $25, usually you can have them serve the opposing party. If your informa pauperis is granted, they will also waive this $25 service fee. Now, you cannot serve the opposing party yourself. Somebody else has to do it. So the best way to do it is to have the sheriff do it. And that way, the sheriff is going to provide you with an affidavit of service. It's basically a sworn statement by the sheriff saying that they serve the document on the opposing party. Once that's done, the opposing party has 30 days to answer. They must file an answer with the court and serve you with a copy of that answer as well. Okay. Now, for the purposes of simplicity, let's say that we filled out our documents, we filed them, We've served the opposing party. They haven't responded for 30 days. Now you can move forward to requesting a hearing. Okay? The requesting hearing document is found on this website as well, and has the same heading as before, except it says request for hearing this time. Your information, defendant's information, whether or not they're agreeing or not. And usually if it's contested, whether they agree or not, you'll know by this point because somebody will have called you and told you, you need to pay your child support, I'm not doing anything, or said nothing, in which case you can usually say that it's not contested, or said that they agree. Fill in all the relevant information, child custody at issue. No, because you're just requesting a modification. How much time? This is an automatic 30 minutes, which is a good rule of thumb for pro se litigants. Sometimes it takes them a little bit longer than what other people. And if you have to put people on the stand and you have witnesses and documents you need to introduce, you'll need that time. All right. Once that's filled out, make 2 copies, take it to court, file it. The court will assign a hearing date, let you know when that is, give you a document to that effect, and then you'll have to serve that as well on the opposing party. Now, in family court cases, there's a family court rule that says if the opposing party hasn't answered, that the service of that final hearing has to be done by certified mail, return receipt requested. I just advise everyone in these clinics that they should always send that notice of hearing by certified mail, return receipt requested. Now, if you take it to the post office, just tell them you need it certified and you need it return receipt requested. They'll hook you up, you can pay them, and they'll send it that way. Now, we're at the hearing. So at the hearing date, you're gonna appear in court, you're gonna dress appropriately, slacks, nice shirt, no shorts, no flip-flops. This is the script for your testimony. It's everything that you need to cover during that hearing for the judge. Sometimes the judge will ask you specific questions. Sometimes the judge won't. I would say in a child support modification hearing, the judge is going to ask you some questions, so be prepared to answer questions about your income and your expenses and why you're not able to meet the current support obligation. This will give you a good idea about what subjects you need to cover in order to be prepared for that, okay? All right. All right. Just gonna scroll through my hearing script since we covered it in a different way. Okay, so like I said previously, on that court hearing date, you'll need to bring any evidence you have. That means recent pay stubs, expenses, medical documentation of a health condition or a disability, high school graduation notice, anything that's relevant to your change in circumstances that warrants your modification. Bring multiple copies. You'll need a copy for you, a copy for the opposing party, and a copy for the court. Now, once you've given your testimony, the opposing party will be given an opportunity to also respond if they appear. If they don't appear, hopefully the judge will grant your request for a reduction. Now, of course, in some cases, child support modifications can get complicated depending on what the circumstances are. If you think you need assistance, you can always contact our offices for assistance by going to our statewide intake line. The number's right here, 346.
That's okay. We'll post all that information
Okay.
with the put the video up on YouTube, and that'll happen pretty quickly. Thanks, Stephanie. What a great presentation. It looks like
Thank you.
all the forms are there on the website, and you gave such a great explanation of the importance of filling all those out and having all that information. So that was terrific. There are a couple of questions.
Okay.
And so first, what if I got a raise, but I really need the money for my expenses? Is that a substantial change of circumstances that my ex-wife can use to get more child support?
Possibly.
It depends on how big of a raise, huh?
It does. It does depend on how big of a raise. But yes, just like decreases in income can be a change that warrants a modification, an increase in income can also be a change.
And then if I don't have a computer, can I get these forms from the courthouse?
You can, and it's my understanding it depends on what courthouse you go to, but usually what they do is charge for the forms. I will say that at Legal Services, we hold clinics pretty regularly on child support and divorce. And, we also sometimes have these forms available. And if, you might want to attend one of those clinics and see and get a packet if possible.
Yeah, that's a great idea. And those are always on our website at sclegal.org on the calendar section of that website. Usually all of the clinics that are being held around the state, you can find them there and get a registration link. So yeah, that's a good way to get these forms, is to go to one of our clinics that we hold a lot of. So
I will say that I just add on that, just a quick note that I heard recently. It's my understanding that I guess the courts have stated that individuals who have filled out the forms on a computer have been faring better.
Instead of by hand, you mean, or whatever?
Yeah, instead of by hand, in which case it might be worth your while to go to maybe a library or somewhere where they do have internet access and printing and those forms available in order to fill them out that way and print them out.
Yeah, that's a really good idea too, for sure. Okay. Well, great presentation, Stephanie. Thank you so much. We really do appreciate your time in putting this together and sharing it with our audience today. It was excellent. I'm sure our listeners will get a lot out of it. And I want to say to our audience, if you found this helpful, or if you know someone else that it might be helpful for, please definitely go to our YouTube channel where this video recording of this episode today will be posted, and you can share this broadcast out to whoever. You can look at it again, get some more information. We want as many people as possible to get the important information that we bring to you on Level Up Law, and this information is no exception to that. And while you're at our YouTube channel, we really appreciate it if you not only like this video, but subscribe to our YouTube channel, and that way you'll get notifications. You can sign up for the notifications every time we post a new video. So that's a great way to get information on all kinds of legal topics that we're sharing with our audience on a weekly basis. And also just check out our social media, Facebook, Twitter, Instagram, LinkedIn, and all those wonderful places. We are always putting out a lot of great information on social media, but also on our websites at sclegal.org and also lawhelp/sc. So we'll provide that information in the description below this video for you. And then I want to ask our audience to be sure to tune in next week for episode 3 in this awesome series that Stephanie's Employment Law Unit has put together for Second Chances Month. Next week on Tuesday at noon, we'll be talking about proper identification. Do you have it? How do you get it? And that sort of thing. So that will be really important for those of you who are having that issue. So definitely check that out and register. You can do that again on our website, Facebook page, and any of those. So again, Stephanie, thanks so much for today and for putting all this together. We really do appreciate it. And thanks again to our audience for tuning in today on Level Up Law.
Thanks, Susie. It's always a pleasure.
Thank you. Okay, and that concludes today's webinar.